All right, hello everyone. My name is Mark Gough. I am an assistant professor at Penn State University, and I am the moderator of today's session, We Are Not Immune, Implicit Bias, Procedural Fairness, and the Impact of Virtual Hearings. I have the pleasure of introducing panelists and neutrals, Lee Hornberger and Betty Widgeon. And just some housekeeping before we begin. Lee has shared a file over the chat which contains some of the links that we're going to be relying on today. So you'll have, you can download that and have it for future reference. And if you have questions throughout the presentation, please ask them in the chat. I will be monitoring the chat throughout this process, and I will have Betty and Lee address your questions at the end of the session. But for now, we're going to start with a very we're going to start with the video.
No, don't. Please don't touch them. I'll take care of those.
All right, let me give you a hand.
No, don't. No. You're making me miss my train. How much is this salad?
$2.
Well, I'm not sure that I have that much. $1. Here's some more. Here's some more.
All right, $1.52. There you go, lady.
Thank you. Napkin?
Surely.
My salad. That's my salad. Thank you. Oh my God. Oh my Lord.
We often say that a picture paints 1,000 words, and if so, perhaps a brief video clip like this can paint 10,000 words or more. If there's time at the end, we may want to discuss our reactions to the lunch date. During the past 5 years or so, we've heard a lot about implicit bias, but there have been very few open discussions about implicit bias by arbitrators, mediators, and judges. Well, the short answer is we're affected the same as everyone else. Because of our positions, however, we must be attuned to how our biases impact those we serve and how they affect procedural fairness and the integrity of the profession as a whole. Implicit bias is not a pejorative term. It's part of the human condition, and all people have implicit biases. It becomes a problem, though, when our implicit bias impacts our decision-making in a way that may put another person or a group at a disadvantage without us realizing it. It's part of our thinking that's unconscious, and it's really served us well for a long time, but we often think that our first impressions are accurate and we decide to go with them. However, sometimes these impressions and feelings mislead us, and third parties are actually able to see our errors better than we are. Implicit bias is our brains on autopilot. So we take shortcuts to fill in the gaps and we apply stereotypes automatically. In his book, Thinking Fast and Slow, Daniel Kahneman describes this unconscious versus conscious thought process as system 1 and system 2 thinking. System 1 thinking is fast, it's intuitive and emotional, it's automatic, and it guides everyday decisions, but it's also error prone. You know, we make a lot of instant judgments every day. We make snap judgments regarding attractiveness, education level, and whether one is well-spoken or well-dressed. And over time, people have ingrained affinities around other people's gender, age, personality, race, appearance, and other attributes. But they're often grounded in stereotypes. System 2 is more deliberative, and it looks for more detail before reaching conclusions. So right now, I'm going to pause, and I want you to look at a slide of 2 pictures. Now, as you're looking, who is the felon? So Mark, you can take that down now. Thank you. You know, if our system one was in control, it likely would have told us, well, she doesn't look that much like what I think of when I think of a felon, but that guy probably does. Now, if we had tuned in a little bit more to system two thinking, we might have Googled Martha Stewart and Snoop Dogg and found out that they both have felony records, and also that they are great friends, apparently. But this would have taken more time, and we don't always take the time to go to that further step. You may be aware of the studies about how musicians were selected for symphony orchestras from the 1950s through the 1970s. They auditioned in person in front of judges who were a majority male group, and very few women were selected. The male judges had an unconscious affinity for other males. In an effort to correct this inequity, the judges had the applicants audition behind a curtain, and this resulted in an increase in the number of women selected. When they added carpet so that the judges couldn't hear the sound of the footsteps, there was another 10% increase in the female applicants selected. Now, choosing the best musicians is a highly discretionary decision, and System 1 thinking used shortcuts to make that decision easier. Let's think about these intuitive assumptions: that the male is probably the more skilled attorney or the more astute financial planner or stockbroker. And what about bankers in general? Who hasn't mistaken the male to be the bank manager, only to be surprised to find that the woman is the manager and his boss? I know I have. Or we may judge the slim, attractive person as more organized than her overweight counterpart. We might conclude that she demonstrates more restraint, and therefore she will be the better arbitrator or fact finder. We may have initial thoughts that a white arbitrator will be more experienced and more intelligent than a person of color. And our minds can easily go on and on, filling in the blanks so quickly that we don't really recognize that it's happening. Did you know, by the way, that many minorities are skeptical of arbitration in the first place? Because there is a notion, and that's supported by some studies, that people of color don't fare nearly as well as their white counterparts when they do win in arbitration or mediation. And conversely, when they are required to pay, that is, when they lose, they generally are required to pay more than their white counterparts. So how do we manage this and change course? Well, first of all, we recognize and acknowledge that implicit bias exists, and then we can decide to rewrite the scripts. We'll see examples all around us once we recognize it. Arbitrators and mediators, we could make a checklist similar to the implicit bias bench card that some judges place within their eyesight at their benches. We could practice being more mindful of whether we are deferring to the male instead of the female, to the attorney over the self-represented person, to the person or the people who look more like us than those who are unfamiliar, and those that we're more uncomfortable around. Programs like this, you're attending this webinar today, this meeting today. We could take advantage of similar ones that are presented seemingly everywhere during these times by LIRA, the American Bar Association, the National Academy of Arbitrators, state bar groups in almost every state. We could join a book club and discuss implicit bias and the injustices that can undermine our efforts to be fair and just, and to make sure that everyone who leaves our presence feels that they actually have been heard fairly. Now, we're going to discuss a little bit more about these later when we move into procedural fairness and justice. But let's just remember for right now, just because we put on the neutral hat or a black robe, it doesn't follow that our biases vanish or that we're no longer affected by them. And when we fail to acknowledge them, we have no incentives to question our actions or to try to make improvements. The more aware we are of our biases and these issues, the more likely we will be able to diffuse them or to maneuver around them. And that can lead to an increased trust in our profession. Now, Lee is going to share some additional examples at this time. Lee?
Let's watch a video clip from a U.S. Senate hearing involving a discussion between Louisiana Senator John Kennedy and then Attorney General nominee Judge Merrick Garland. Mark?
Yeah, I'm having, the video's not loading on my end. Let me.
Talk about this later, but I want to ask you about this concept of bias.
Yeah.
Does that mean I'm a racist no matter what I do or what I think? I'm a racist, but I don't know I'm a racist?
Okay, the label racist is not one that I would apply like that. Implicit bias just means that every human being has biases. That's part of what it means to be a human being. And the point of examining our implicit biases is to bring our conscious mind up to our unconscious mind and to know when we're behaving in a stereotyped way. Everybody has stereotypes. It's not possible to go through life without working through stereotypes. And implicit biases are the ones that we don't recognize our behavior. That doesn't make you racist, no.
Who judges that? Doesn't the person judging me have his own implicit bias? How do I know his implicit bias isn't worse than my implicit bias?
I agree, but I'm not judging you, Senator, and I don't know
I'm not asking you
who
to,
would be judging.
But somebody, if you say you have implicit bias, that's a pejorative statement. I'm not saying you're being mean. You're not a mean guy. That's obvious. You're a nice guy. If you say somebody has implicit bias, somebody's got to make that subjective judgment, and the person making that subjective judgment has implicit bias. If it's part of being a human, then how do you know who wins?
Fair enough, but if we say that all people have implicit bias, it's not, you shouldn't take it as pejorative. This is just an element of the human condition.
There was a lot to unpack there. Quite frankly, then Judge, now Attorney General Garland, does a great job of describing what implicit bias is and what it is not. Senator Kennedy is unfamiliar with implicit bias and was clearly feeling defensive, which is not unusual. But implicit bias is not a derogatory term. It is a part of the human condition. By definition, it is an unconscious feeling. Senator Kennedy was not being called a racist. No one is trying to figure out who wins. No judgment is being made. Senator Kennedy's response is typical System 1 thinking. He was operating at gut level, focused on the word bias, thinking he was being called a racist. System 2 thinking is slow, conscious, effortful, involved in complex decisions, and is more reliable. This was Judge Garland's presentation. It was slow, thoughtful, and complex. System 1 thinking is why two people can see the same thing, but come away with a completely different version of events. Harry Truman described this in his book, Plain Speaking, where he observed that two people can see the same event, tell two different versions, yet neither one is lying because they saw the event through the prism of their own experiences. There is a jury instruction that recognizes this condition. For example, the Michigan instruction describes how people can see the same event and describe the same event differently, but that does not mean they are lying. The instruction says people see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. In other words, the instruction acknowledges that system one thinking is why a witness may be wrong about what they thought they saw, and not that the witness is lying. In fact, the world around us reinforces our stereotypes all the time. IBM computer Watson has a male voice, reminding us he is in charge, while Siri and Alexa use female voices to remind us that they are assistants. These products reinforce the stereotype that the male is in charge and the female is the assistant. Studies show that stereotypes can influence our behavior, even if we consciously believe those stereotypes are not true. We may make decisions that we find unacceptable if we pause to analyze the issue more closely, if we use system two, more deliberative thinking. Here are some real-life examples. In a controlled study, resumes were prepared for candidates for job interviews. The resumes were identical. The only difference was the name on the resume. One name was easily identified as black, while the other as white. The callback rate for the white applicant was 9.5. The callback rate for the black applicant was 6.4. In another exercise, 60 attorneys were given a research memo they were told was written by a third-year law student. Half were told it was by a black student. The other half were told it was by a white student. The black writer scored 3.2 out of 5, and the white writer 4.1 out of 5. Let's examine the recent work of an executive director of a human services organization. She measured the time each social worker spent with each client. She then measured the time each social worker spent with each client based on whether the client looked like the social worker. If the client did not look like the social worker spent less time with the client. This difference occurred with respect to both race and gender, but was more pronounced with respect to race. That data was reviewed with the staff, and soon the difference was reduced. This is a classic example of implicit bias. It is present, but it is unconscious. More important, it can be overcome. System one unconscious thinking caused social workers to spend less time with people who did not look like them. System two, conscious deliberative thinking, helped them overcome the implicit bias. The executive director separated the things out in the data to identify the bias and improve performance. And it worked. This is a technique that we can use as well. Stereotypes can influence our behavior, even if we consciously believe these stereotypes are not true. I am confident that these social workers did not consciously entertain stereotypes of their clients, but implicit bias clearly influenced their behavior. The way they handled these counseling sessions did not mean they were sexist or racist, like Senator Kennedy worried. It just meant they were human. How do we identify implicit biases? An interesting and easy way to identify our implicit biases is to take the Harvard implicit bias test, and the link to that test is among the other links in the link list in the chat room that I call the handout. Over the years, this test has shown that 80% of white test takers and 40% of Black test takers showed a pro-white bias. How do we overcome implicit bias? Sixth Circuit Court of Appeals Judge Bernice Donald recently observed that judges view their job functions as judges through the lens of their experiences, and all are impacted by biases and stereotypes and other cognitive functions that enable us to take shortcuts in what we do. As arbitrators and neutrals, we want to be fair. We want to make the correct decision. We do not want an underlying unconscious bias guiding our decision-making. I am confident we all believe we are using system 2 in making decisions. Being aware of implicit bias will help us make fact-based decisions and not rely on our gut. Actually, the notion that we would rely on our gut to make a decision seems peculiar when we consider the level of education and experience we must have in order to serve as an arbitrator or otherwise work in labor relations. Implicit bias affects discretionary decisions, such as scheduling and motion practice. If we are under stress with time pressure, multitasking, and have incomplete data, the risk of reliance on system 1 thinking is higher when making discretionary decisions. A great example of how time pressure can impact was a study of parole judges in Israel. Their entire day was spent reviewing applications for parole. On average, these judges spent about 6 minutes on each case, and about 35% of the requests were approved. The time of each decision was recorded, as were the 3 food breaks for these judges. 65% of the requests that were reviewed right after each meal were granted. However, in the 2 hours before the next meal, the rate of approval steadily dropped to about 0. The clear finding was that the judges who are tired and hungry tend to fall back on the easier default position of denying requests for parole. This was system 1 thinking. Arbitrators and the rest of us are no different than judges in this respect. With that, here is another video for us to review that might help make implicit bias a little more obvious.
You see this and you wonder, did he lose his keys or is he blatantly stealing that bike? In broad daylight, he hammers and then saws on the chain. When that doesn't work, he pulls out an industrial-sized bolt cutter. And when he's asked, he fesses up.
You lost the lock?
No, not exactly.
But he's not a real thief. Justin Kelly is an actor, and our hidden cameras are rolling.
What happened? Nothing. I can't get through the lock. I mean, I know it's weird, but you wouldn't happen to know whose bike this is, would you? No. All right, good. Thank you.
It was odd that somebody had all that equipment.
But you didn't do anything.
No?
That's true.
That's the bottom line.
Lots of people stop and stare. A few even question the actor.
I guess I have to ask, is that your bike?
I guess technically no.
Okay.
Okay. Bye.
Good luck.
In over an hour, about 100 people pass by. Only George and Arlene try to stop him. Some tell us they plan to call the police later. Others say they're scared. Keep moving. This woman and her friends give our thief the benefit of the doubt. When we ask why, Bisa Washington tells us first impressions matter.
I remember thinking young white men don't usually carry burglar tools.
So we all make assumptions, huh?
Yeah.
I'm thinking maybe he works for the park.
We replace our white thief with this young man, Matlock. Remember, both actors dress in a similar way and are about the same age.
Is that your bike?
Nah.
Then what are you cutting the chain for?
Right away. Right away, somebody yelled. Wow.
Within seconds, another person confronts our thief.
Is that your bike?
Technically, it's not, but it's gonna be mine.
More people converge.
Is that on the cell phone? You call the police. He's like stealing somebody's bike.
Are you taking that bike? That's your bike?
No, it's not, sir.
Oh, why are you doing that?
Is this any of y'all bikes? Is this your bike?
It's not, it belongs
No,
to
but whoever's it is.
It belongs to someone.
To who?
Well, not to you.
And sure enough, one man whips out a cell phone to call 911.
Yeah, there's someone taking a bike here.
Our actor triggers more reaction. Some people are even snapping pictures for evidence.
I got you, bud. I got you.
Guy's stealing the bike. Whose bike's over here?
Once everyone moves away, we reset our cameras, and within minutes, another outraged man is yelling.
Are you trying to steal that bike?
Excuse me, sir, but the bike's been here for days. Like, no one's gonna take it.
Well, that's not your bike then.
Yeah,
you can't just come in and take something from somebody.
Excuse me, sir.
Okay, I'll just take your tools away then. This yours, sir?
Please, sir, don't touch my stuff, sir. Please, sir, do not touch my stuff.
You're
please.
touching somebody else's stuff.
Yeah, all right, but this has been here. Like, who's gonna take it?
Well, that doesn't make it your property.
Technically, it does.
No, it doesn't. Technically, it's not yours to take.
All right, sir.
When we bring out our cameras, David Robb wants us to go after the thief.
That kid in the red shirt.
He's hacking away at a bike that's not his.
Days, and he has a right to take it and steal it. And he's come here with...
Back to you, Lee.
Thank you. So in that video, we have seen several examples of System 1 thinking. Engaging with people who are different helps break down stereotypes and counters implicit bias. Encouraging diversity also helps to break down stereotypes. Having a diverse workforce is helpful for the arbitration process and for employees and other individuals who are involved with the arbitration process. To disrupt implicit bias in personnel hiring, we should set specific criteria beforehand, set diversity goals for supervisors. We should advise them that their evaluations will have diversity goals. Securing diversity takes a commitment, but it is helpful in reducing implicit bias. If arbitrators and neutrals are diverse, then people who are involved with the arbitration process will more likely have confidence in the proceedings. Diversity is not enough, as that executive director discovered. We need to analyze our data to identify implicit bias and use that data to help arbitrators and those who select arbitrators and neutrals to overcome their subconscious implicit biases. Now, let's segue back to Betty.
Thank you, Lee. And I want to shift gears just a bit here to explore procedural fairness. Procedural fairness and procedural justice are interchangeable terms, and they involve the concept of fair and just procedures for everyone. Now, studies have shown that across racial spectrums, and the study I'm thinking of included whites, Blacks, and Hispanics, all these groups rated procedural fairness as extremely important. It includes the following components: voice, neutrality, respect and dignified treatment or civility, and trustworthy authority. So for the sake of brevity today, I'm going to touch on voice very briefly. Then I'm going to combine neutrality with respect and civility. I'll omit the trustworthy authority at this point because it relates specifically to court appearances. So let's just begin with voice. You know, arbitrators are rarely accused of preventing the parties from exercising voice. Instead, it may be seen that it's just the opposite. We hear everything from everyone, that we let everything in. But having the opportunity to fully express her side of the story can be very important when someone is used to being overlooked or is not expected or allowed to speak. And more than just having the opportunity to be heard, it's important that the person telling his side of the story also gets the impression that the person he's telling it to, the person in authority, is listening. So it's important not to just have your day in court, but to have a meaningful day in court. Now, moving on to neutrality. We are neutrals. That's our title. Neutrality is our stock in trade. And without it, we lose all credibility and our judgment regarding our judgment, and our decisions can be overturned. Our attitude comes across during the hearing. Now, you may have heard this following expression: what you're doing is speaking so loudly, I really can't hear what you're saying. So what does our body language say at the hearing? And what about our mannerisms? What are our faces showing? If we do manage to keep a poker face during the hearing, what about our focus? Are we focused on one side more positively or negatively than on the other side? Are we appearing to take notes when one side is speaking, but not so much for the other side? And is that focus showing that we're more comfortable with one side than with the other? Bringing in respect and civility. What about our tone inside the hearing and outside? You've probably heard about or experienced memorable instances of people responding in strikingly different ways, depending on the tone and the manner in which the bad news is delivered. Showing respect is being civil. It's acknowledging that those in the witness seat, they are indeed people first, regardless of the alleged or the proven facts attached to them. And what about our decisions? Arbitrators do most of our speaking through our decisions, and our tone can come through loudly and clearly in the words that we use and how we decide to focus our attention. In other words, respect and civility, or the lack thereof, show up in our decisions. There's a very special person in our office who reads just about everything I write, and the focus is on snarkiness. So she'll flag that. This focus is to help me consider, how can I say what I have to say more respectfully and with more civility? Here are a couple of examples. The arbitrator finds that grievant is an unrehabilitated liar. Or I could say, the arbitrator found grievance testimony inconsistent and less persuasive. Therefore, she discounted it accordingly. Another example, management's position is untenable, indefensible, and totally unbelievable, versus the arbitrator found management's proofs less persuasive than the union's. Now, another caution regarding what and how we write. Arbitrators must be careful in the way that we summarize background facts in our decisions and take care that we aren't just simply accepting or republishing information from just one of the parties' points of view. The other day, a management attorney handed me an article at the end of a hearing, and he had highlighted several parts of it, which he wanted me to be sure to note and to consider in writing my decision. That article asserted a stereotype that a grievant or an employee generally has more to lose than the employer or the manager or the management, and therefore, all other things being equal, the arbitrator should give the advantage to management as likely being more truthful. I thanked both sides for their submissions, but I stated clearly that I side with the overwhelming majority of arbitrators who do not accept that premise. Now, a final word about prejudging. We know that we're drawn more to people who look and act and think like us than we are to people who look, think, and act differently. It's more comfortable for us, and especially until we get to know those others better. But how does this all translate for neutrals? Well, we must be diligent to make sure that we really are listening to both sides with an open mind, and that we haven't prejudged the strength of a party's case because of how readily we can relate to them. So let's take a look at this cartoon and see if we recognize ourselves. You see the person sitting high and looking down on the other person, and his assessment is surely not guilty. Next case. Thank you, Mark. We may be thinking, surely we're above all that, but are we really? Several years ago, I read an article by Carol Izumi, a professor, clinical law professor at the University of California, Hastings College of Law, and it was titled Implicit Bias and the Illusion of Mediator Neutrality. She followed this up with a second article in 2017, and it's titled Implicit Bias and Prejudice in Mediation. These articles started me thinking more about implicit bias as it relates to all neutrals, and particularly to arbitrators, fact finders, and judges. And we've also added that link to those articles in the resource materials that are linked in the chat. Professor Izumi encourages arbitrators, fact finders, mediators, all neutrals to dive deeper. Don't just go with the flow and assume that when we sit down at the table and call the hearing to order, our minds are starting with a blank slate. In other words, we don't stop being affected by all the stereotypes, the prejudices, the misinformation that we've been exposed to during the past 10 or 20 or 40, even 50 years, just because we close the conference room door and start the hearing. We might compare that notion to expecting that the jury really can and does disregard leaked and extremely prejudicial information just by being told that they should. No, those images, like stereotypes, aren't easily erased. And now Lee is going to discuss implicit bias in virtual hearings. Lee?
Thank you, Betty. I will be discussing the impact of Zoom hearings. This will include how do we best create an arbitration system that works for everyone while using Zoom. The Conference of Chief Justices and the Conference of Court Administrators in its guiding principles says, quote, technology is not a panacea. It does not and should not replace the fundamentally human character of justice. However, it provides unique opportunities for courts to ensure that all parties to a dispute, regardless of race, ethnicity, gender, English proficiency, disability, economic status, or whether they are self-represented, have an opportunity to meaningfully participate in court processes and be heard by a neutral third party who will render a speedy and a fair decision, end quote. We have to be conscious of how we come across to people. The watchwords for virtual hearings are professionalism and respect. We have to be kind, be kind. We should check into the Zoom event at least 5 minutes early. This helps make sure the Zoom link works and that we are in the right place. We should leave time for mistakes. We should not be doing something for the first time while we are in a virtual event. Slowing down can help us to do a better and a fairer job. We should be aware of the dynamics of virtual hearings. These include the need to go slow and the need for transparency and preparation. We should be mindful of when we are not on mute. We should pause before speaking. There can be people entering the room. Yes, entering the room. We should close the door. As indicated in ABA Formal Opinion 498, which is a very important document, quote, client-related meetings or information should not be overheard or seen by others in the household, the office, or other remote location, or by other third parties. The Michigan Supreme Court Professionalism Principles Order says, quote, we should ensure that self-represented litigants have equal access to the legal system, end quote. Virtual hearings require our continuing focus. We can be mentally exhausted after a day of Zoom hearing. Procedural fairness takes time. We should respect people's space in video conferences by having frequent breaks. Slowing down can help us do a better and a fairer job. University of Colorado Social Science, Nila Viverio said, quote, respect people's space in long video conference settings by building in frequent breaks due to a variety of factors, such as the need to care for oneself or for a family member with disability. Participants may need frequent breaks, end quote. We have the issue of multitasking while on Zoom. We believe we can listen to virtual proceedings while at the same time we are word processing, searching the web, or doing other things. When this occurs, we are sending the message that we do not care. There are things that we can do to help us to stop multitasking. We can put a yellow Post-it note on our smartphone or iPad. The note would say, why are you looking at me? There is a necessity to do some multitasking when multitasking concerns the case at hand. This can occur when we need to take notes. An arbitrator, while handwriting notes while on Zoom, can incorrectly appear to be distracted. Participants should be told ahead of time, I will be taking notes. Transparency and courtesy are important. The implicit bias bench card states, quote, take notes and rely on those notes over memory, end quote. The ABA formal opinion says, quote, lawyers practicing virtually, even on short notice, must have reliable access to client contact information. There is a discussion about whether the fact finder can make credibility determinations in virtual hearings as well as in an in-person hearing. Jennifer Shulkin, in her virtual hearings article, stated, quote, the negative effects of implicit bias and racial prejudice might actually be more pronounced in person than virtually, where video and audio capabilities limit the judge's access to a full picture. The objection that virtual hearings limit information available to the judge is exactly the argument in favor of adopting them. Viewing defendants on a computer screen rather than a few yards away would likely allow judges to feel less personally connected to, and as indicated by the author, or repulsed by the individuals involved, make less emotional decisions, and be more focused on resolving issues as accurately as possible, end quote. There is a concern that witnesses can cheat during virtual hearings. There should be a protocol or Miranda warnings to give witnesses before they testify. The Michigan Supreme Court Professional and Principles Order indicates, quote, we should maintain control and direction of judicial proceedings, recognizing that we have both the obligation and the authority to ensure that such proceedings are conducted in a civil and fair-minded manner, end quote. There are some additional things we should remember. We should be aware of what our virtual backgrounds or our real backgrounds symbolize. We are dealing with different people of different cultures. This is not the time or the place to overly express ourselves. We should surround ourselves with less. Sometimes less is better. Michigan State University social science researcher Amy Bonami said, quote, unconscious bias includes using language, symbolism, and nonverbal cues that reinforce normative social identities with respect to gender, race, sexual preference, and economic status. For example, she said, when virtual background of a Zoom meeting attendee has pictures of his or her wedding, it unintentionally reinforces the idea that marriage is most fitting between opposite sexes, end quote. Michelle Pomerlee's article in Forbes said, quote, being cognizant about unconscious bias can make us more thoughtful about our interactions and the opportunities we offer to our people, end quote. In conclusion, virtual hearings are an opportunity. They provide opportunities for more participants to appear. There are cost and time savings. On the other hand, there are technology risks. We should be professional. We should be kind. Betty and I have addressed number one, what is implicit bias and how can we disrupt it? Two, how can implicit bias impact procedural fairness? Three, how is implicit bias implicated in Zoom hearings? Thank you.
Thank you, Lee and Betty. Now for the remaining time, I'd like to open it up to the audience for any questions. Please, either using the reactions tab, kind of raise your hand and I can call on you if you want to verbally ask a question, and or post it in the chat and I will present it to Lee and or Betty. All right. So first question, this one's directed at Betty. So if we know that our first impression biases can affect us as we're viewing the parties, what can we do, or how can we avoid being negatively affected by these instances where some parties may be at a disadvantage because they don't have, let's just say, sharp, uncluttered backgrounds, or don't have steady internet connections?
Okay, great question. You know, going back to what I mentioned earlier about awareness, about how once we are aware that we have these biases, we see them all around, but that actually becomes a check of sorts for us. When we come to recognize that there won't always be an even playing ground, that everybody won't have the same background or the same access to really good internet connection or whatever. So we recognize that, and I think we basically prepare ourselves beforehand that there will be, some people say there will be glitches, there will be disturbances, there will be negative thoughts that might immediately come to mind. And then we make the decision consciously to refocus back on the main event of what is that witness saying? What is her contribution to the rest of the information that we receive? And then that conscious decision again, that I'm going to refocus on that and not on the background noise or the fact that the lighting is off and one side of the face is dark, or the screen gets frozen a few seconds here and there because the internet is going in and out. So I think what I'm saying is, if we are aware that these things can affect us, that becomes a check for us, almost like that bench card that some of the judges take to the bench. So that would be my answer.
All right, thank you. All right, and again, you can either message me your questions directly or post them publicly. But so the next question, and I guess this is for Lee or Betty, it says, a lot of what you discussed today involved kind of individual level decisions, but how can you ensure at an institutional level that people are in fact doing the work? And I assume that means doing the work to control their implicit biases.
I'll jump in there firstly, even though I just answered the last question, because what my immediate thought is that we hear about that a lot. What about the institution? Well, institutions are made of individuals just like us. And so that's why for me, I can't always make a big speech that's going to affect a whole institution, but I can start where I am and start talking about the things that I know, which is how neutrals respond, and the things that we sometimes think we're above, such as implicit bias, and we're really not. So just kind of to get off that horse a little bit and understand that we didn't park our biases outside. We haven't been in some other universe while everybody else has been affected by these biases that we see. So perhaps I'm still sticking with the individual, but if there are enough of us, then I think that we can get together, and as we have opportunities to present to larger groups, we can expose this information, and that's how we can try to reach a different level. Lee, you may have something different to say about that.
Well, it's a provocative question, and it walks us into the back door of meritocracy, which is a loaded word. And when we're talking about arbitrator and neutral selection, we're walking into the back door of meritocracy. And it's delicate. So if the goal is to pick the most, quote, qualified, end quote, neutral on the list in the history of the world, what we're trying to do is going to be difficult. I could be wrong, but it's going to be difficult. My thinking is with implicit bias, we all have it. We have to be thinking about it. And when we're making decisions within organizations, we should be acting accordingly. So what we're doing is not part of implicit bias. And we should be looking at the end result to see if the chain that led to the end result was full of implicit bias. Do we have an officer component that is diverse? That's one goal. Do we have an arbitrator end product that's diverse in a different environment? That's another goal. So regardless of what the question was, that's an attempted answer. Thank you.
All right, thank you very much, Lee and Betty. Out of respect for the time, for the clock, we are now 2 minutes over. So please join me in thanking our panelists and enjoy the remaining Lyra sessions. Thank you very much, everyone.
Thanks, Mark.